Let your verdict give us the answer.
Sir, you grew up in Bombay.
Yes. I was in school in Bombay until it was time for me to go to college. And since my father himself was a scholarship boy in Ferguson College, Pune, he decided that I should go to Pune. So for 2 years I was in the Ferguson College, occupying that very room which he had occupied about 40 years earlier.
All right, sir. Before that, in school, could you tell us about parents, teachers?
Yeah. My school was a fairly modest school, and my father, in a sense, wanted me to send a school which was almost austere. All my colleagues were really from the middle class, and we did not have the lavish ways of spending which even some of the schools in Bombay in those days had. And that was for a purpose, that I should really grow up in the atmosphere of the family. We were really a middle class family and a professional family, and that was the atmosphere in which we grew up. In fact, I studied up to matriculation in Gujarati as the first language, and I developed my love for Sanskrit at the same time.
All right.
Thereafter, I went to Ferguson College in Pune, which was again a school, an institution run by Deccan Education Society with very high values in mind. In fact, professors and teachers of very high eminence came and worked there on what would be regarded almost as a pittance of a salary. And people like Paranspe, who were wranglers, Karve, who were men of great eminence in their own field, used to teach there at a very modest level of salary. And therefore, throughout my education, there was no great particular affection for accumulating money. And in a way, that was the atmosphere in those days. Gandhian values were still values which prevailed not only during speeches, but during the actual in the action of the various leaders themselves.
Okay, sir.
In fact, I remember somebody I knew a little, namely Vaikunthlal Mehta, when he was offered the finance ministership of Bombay, as the United State was called, he declined on the ground that he was doing much better as a person running the cooperative movement among banking, in banking in Maharashtra and in Gujarat. And he had to be persuaded to give up that manager's post in order to become a finance minister. I think something which is not likely to recur in our present atmosphere.
Correct. So then you went to Government Law College, Bombay?
Then from there I went to the Government Law College, and we had a remarkable system at that time of very eminent young lawyers whose eminence was not yet known, come and give lectures in the morning before the court started their work. So they would come from between 8:30 and 10 o'clock. And among the roll of lectures which we had was Palkhiwala, to my mind the greatest lawyer I have worked with, and Chandrachud, one of our great judges who ultimately became the Chief Justice of India. And we first saw them as teachers trying to control a slightly unruly class.
And you had some famous classmates?
We also, I must say, I'm a little proud of that, because it may be a coincidence, but we had 4 or 5 colleagues who ultimately were men of great eminence in their own field, particularly the field of law. The senior most of that was Nariman. Then was Bandare, who is now the governor in Orissa. Then one of my colleagues was Anil Diwan, then Soli Sorabji. So it's quite a remarkable coincidence that within a period of about a span of 3 years, we had lawyers who did so well 30 years later, although one wouldn't have guessed it easily at that time.
All right, sir. Tell us about sharing a classroom with Fali Nariman, Soli Sorabji.
No, you see, in a way, the college itself had supporting work apart from a good library and a good staff to teach. For instance, we had a law college parliament, and we used to take our parliamentary duties very seriously, and we regularly had a prime minister, we had elections and a prime minister and leaders of opposition. And I think on one distinct occasion we had a vote of no confidence and a change of government, although for reasons totally alien to what you have today.
So tell us about how the involvement of the profession in education. You said that Nani Palkiwala, Justice Chandrachud, they were teaching in the Government Law College. Do you think the situation has changed today with the profession giving back to education?
The situation has changed radically, partly because of the rules of the University Grants Commission and a method by which the permanent staff resents the presence of some stellar performers coming in once in a while and giving lectures. The University Grants Commission comes in because they have a system that if you are a professor or if you are a lecturer, you must have a certain salary and you must have certain hours of work. So we do not accommodate people who would otherwise come to lecture. And my own view would be that even though you may not have eminent practitioners coming to lecture regularly on a bi-weekly basis, surely you can draw upon almost any lawyer in the profession and ask him to give a series of 5 lectures on a theme in which he practices. It won't be a burden on the lawyer because that's his daily bread and butter. He can come and argue or give the lecture without too much preparation. It won't also be, it would be a great pleasure for the students to hear him out on a specific narrow theme. And this meeting ground of actual practitioners and academics is still very much missing and has to be made up.
All right, so what steps do you think we need to take now?
I think what I had actually suggested to the Delhi University, but again it did not work out because of institutional reasons, was that you call upon 10 eminent lawyers from the Supreme Court to take a series of 5 lectures on a theme of their choice and keep it on a Saturday morning, so that every Saturday you will have some legal lion coming and teaching the students a narrow field of law in which he is an expert.
So going back to your life, you got called to the bar in England.
Thereafter, after I graduated from India, I found that I was still too young to start practice because I was below 21. And that was part of the plan, that I should go after my graduation in law to study further in England. My main aim was to go and study for the bar, but you could do concurrently some other course. So I joined the London School of Economics to do my BSc Economics, which was the general degree. And of course that was an extremely absorbing field, and it took more time, I had more interest to do that rather than to do the lectures in law. In fact, curiously, for bar, what was compulsory were the dinners, which were a slightly undelicious lot, at least in 52, 56, which were almost like post-war years. But the work in LSE was very absorbing. And in fact, I had the privilege of representing the London School of Economics in China in 1955.
Wow.
As a student from, from England. And the Chinese could not work out how an English institution should send an Indian to China. They always suspected there was something fishy about this whole exercise.
Wow. Tell us about your experience at the bar.
When I returned to India,
No, sir, I was asking about being called to the bar in England.
Yeah. Well, being the system in England of studying for the bar is like getting trained for a guild. In fact, it comes from that idea that you really meet your colleagues who are lawyers, and you meet them at lunch or dinner, and therefore the whole emphasis on dinners. By the time we joined the bar, examinations had become compulsory, although still the bar was not, bar or the standard of excellence required was not very high to pass the bar exam. We had very good lecturers like McGarry, who later on became the Vice Chancellor. But since the lectures were not compulsory and you could appear for the exam in bits and pieces, you could appear, take 2 papers.
Just a second, sir. Where would these lectures happen?
The lectures would take place in the in a place close to Lincoln's Inn.
Okay.
So again a practicing barrister would come and teach you, but he would be teaching a fairly mixed class, some of whom had done 2 papers in one field or 3 papers in another field, some of whom were raw. So the lectures were not taken as seriously as they are taken today, where the bar is fairly high.
Okay. Tell us about your return to India.
When I was to return to the bar, to India, I had bought my tickets by the short sea route, what we might call or the normal sea route, namely by Suez. No one thought of traveling by plane. I suspect it was much too expensive for a student. And suddenly we received a notice 15 days before the departure that because of the misadventure of Sir Anthony Eden in trying to attack Suez, that route had closed down. So we had to come way around the Cape of Good Hope. And I spent 1 day in Durban and 1 day in Cape Town during the period of apartheid.
Okay.
And it left an indelible impression to see benches where you could not sit, or to see public facilities which we could not use. Although it was a short period, it sort of brought home the concept of equality more vividly than any amount of teaching could. When I returned, the advice given to me by Mr. Sirvai was that although I was a barrister, I must start from the lowest rung for 1 year and do the work in a solicitor's firm where you actually meet the client, take down depositions, prepare affidavits, prepare even affidavits of documents and matters of like nature.
So how did you come in touch with Mr. Sirvai?
I knew Sirvai through a common friend. So I just asked for his advice. And one always had some hesitation about starting in a higher college, in the higher courts, but one always had the ambition to do so. But I was advised that it was for my own good that I should spend 1 year doing work of the very raw junior, the very beginning. And I think it ultimately paid off, because one could see a case developing from the time a client came hesitatingly into your chambers with some problem, and you started working out under the guidance of some senior what the affidavit should be, what we had to find out in the cause of action, what we should file as a complaint. After about a year and a half of this, I started my practice with Mr. Gupte, who was then a senior lawyer in Bombay, a very gentle, persuasive advocate who later on moved to Delhi and ended as the Attorney General of India in his term. Thereafter, I joined for a while chambers of Mr. Manekshaw. But by this time, I had already started arguing in court. And my principle was, and I would advise anyone to do so, that it is much better to argue a small case than to be a second fiddle in a large case. I mean, it's tempting to be in some causes célèbres as the third or the fourth violin, but it's much better to sort of play your own lone fiddle because you get a chance to speak in court. And that is an art which you will never learn unless you actually stand up and argue, make your mistakes, and then are corrected, and then slowly refine the manner of presentation. I therefore sometimes feel a little concerned that so many bright young lawyers want to start in the Supreme Court. Of course, it's the highest court of the land, but I think Supreme Court is something which one should approach after starting practice, at least in the High Court, if not in the district courts for a while, so that you are refined, polished, and you know how to go about your business.
All right, sir. Any inspirational figures from the Bombay Bar that time?
And as I mentioned, Gupte himself was for us a man, a role model, because he was a man of both gentle advocacy and of great integrity. But the two very eminent people at the bar and with whom I had good fortune to work were men of very different character, but both setting great standards in the profession. One was Mr. Sirwai, who was as thorough an advocate as one could have. And once I mentioned that it was like working with him was like working with Arjuna, because who could only see the eye of the bird and not even the whole bird. He would concentrate so intensely on the case that it was to the exclusion of everything else. And he would take very limited number of cases. He was not after collecting a large number of briefs or charging high fees. He was really there to set up or to expound the law as he saw it, as thoroughly as he could. Second, of course, was Palkhiwala, who had already, like a legendary figure by the time we joined. He was in a way a person who took many more briefs than Sirvai would. Although he would be only in one court, he would not abandon a brief in the middle of a case. But his mind was capable of retaining very many different sort of aspects of a case or of cases and come out with them one after the other. And the usual story, almost apocryphal, was that you could instruct him on the way from the library to the court and he would pick up the point. I won't advise that as a good way of preparing a case. But it, I think, was more a tribute to his the speed with which he could pick up a point rather than his actual method.
Okay, so any memories of Mr. Sirvai?
Oh, I have a very large number of very fond memories of Sirvai. He was such a dedicated person that, to give an instance, while I was arguing Antule's case, I had some problem about admissibility of a document. And I just phoned Sirvai and said, Sirvai, I find a little problem about how to get a document admitted because of the methodology insisted on about proof. And he said, very well, we'll look it up and let you know. I was in the middle of the argument. And after I finished 3 hours of argument as I was continuing, then I found Sirvai outside in his shirt and without his coat jacket, just telling me, let's hop across and I shall tell you what the answer is. And he had spent 3 hours on his own working for the case, picked up 2 relevant authorities, brought them all the way to court just in order to help a point. And although I had not taken my lunch and I was looking avidly towards it, I could not but follow him to a side room where he explained very clearly and lucidly what the law was and how I could persuade the court that the document should be admitted. Now, this is the type of help given without, without any reserve to a junior who was trying to make a point in a case. And this is really what I would regard as a love of learning and a sense of brotherhood at the bar.
Any great judges you remember from that?
I had the occasion to appear only once or twice before Chief Justice Chagla, as he was in Bombay. And of course, he was regarded as one of the greatest judges anywhere, both for his learning and above all for his remarkable manners. Chandrachud was a judge in our days. We had very bright commercial judges, in judges like S.T. Desai, K.T. Desai. We also had some judges who, by their presence, could bring in good advocacy, bring out good advocacy. One was Chief Justice Chandrachud, and the second was, of course, curiously, a judge who remained on the bench for a very short while, namely Justice H.R. Gokhale. Although he was afterwards in some controversy about the emergency, he was a splendid judge, both in civil and in criminal matters. And then once we came to the Supreme Court, we had, of course, a whole host of very, very eminent judges would sort of come there, and I would, Bhagwati himself was one of our most profound judges. Late of the recent judges, Venkat Chalaya's judgments come to my mind, and his court manners. And I remember in one case, he very gently reproved a lawyer who had argued long enough, saying, come, Mr. Lawyer, we cannot waste your time, and then close the case.
You mentioned Antule's case.
Yes.
Before and after that case, any memorable experiences doing a case which you felt gave you the confidence to go forward, strike forward in the bar?
The first case of any real importance which I did was the case of censorship of drama called Sakaram Binder. That was a Marathi play written by Vijay Tendulkar, and at the last minute the police stopped performance. Curiously, the police were the censors in those days of dramatic performances. And here was Vijay and a few of his colleagues coming virtually on a Monday, saying that they feared that there may be a impediment to their having the play by the weekend, although no formal order was passed. So we naturally said, wait till the formal order. On Friday afternoon, we suddenly got information that the first performance on Saturday was going to be blocked up. And the police, the first performance on Friday was going to be blocked up. We learned this on Thursday. Now the police never expected that anyone could take action within a day. And our team was ready, and we sort of drafted the document virtually overnight, literally overnight. By Friday morning, the writ petition was ready, and we could move the judge on Friday morning and we could get a stay for the Friday evening performance. That play thereafter had a long history of further blockades, which were again met by writ petitions. Ultimately, the censorship rules themselves were struck down by Justice Kania, then of the Bombay High Court. And one of the remarkable things was that we had to perform that play. And every time there was a word which was censored, the light went on to show what was censored. There were hardly about 10 lines. And even the ladies present couldn't quite understand what was offensive about what was being said. And the censorship rules were struck down, the police powers were reduced, and two interesting results. One was the book was written on the subject, because normally Indian literature is very poor about description of cases and what people feel about them and how the case went. So Marathi book was written called Binders Divas. And lastly, I was told that earlier this year, there was a whole play called Sex and Censorship, in which they showed the play and showed the characters in the play, including the lawyers.
All right, sir. So which year was this in?
This would have been around 75.
Okay.
And thereafter the next was the Antule case, where Mr. Antule was giving or allocating cement, which was a scarce commodity, against a contribution to Indira Gandhi Fund. And the interesting part which people now forget is that Antule in fact accepted that he used to collect it. At one stage he said it in so many words, but in the assembly, so that was supposed to be privileged. And we were able to collect a lot of material which showed the quid pro quo almost working out to 40 rupees per ton. So if you have taken X number of tons, you would pay 40X as the donation to the fund. So it was easy in a way to prove even to a judge who would want strict proof that the amount which was being paid was exactly on a given measure. The result was very interesting. Justice Lentin found that there was quid pro quo. He had written that whole judgment by hand in order to keep the confidentiality of the judgment till it was actually delivered. And when it was delivered, again the results show the hiatus between political thinking and what is required in the rectitude. The assembly again said that full confidence in Mr. Antule, notwithstanding the judgment. But Mrs. Gandhi took a dim view of the fact that Mr. Antule had been virtually caught in the act and he had to step out as the chief minister. Of course, he had resurrection later on, but at that point he had to step out. This was one of the earliest instances of a minister having to demit office because of court orders. Unfortunately, it was not the last instance on the subject. The next case which then came up, which was of some importance, was the case about Back Bay. Land that Back Bay were being sold by the government led by Mr. Nayak at an undervaluation. And it was very interesting to see how the government virtually took a brazen defense that this land belongs to us, so we can sell it at any price we like, a theory which runs contrary to the idea that all public property is trust and you cannot treat public property as if it is private property. The petitioners, interestingly, were Pilu Modi, Mrunal Gore, P.B. Sawant, and a fourth colleague who was one of their colleagues who was in the municipality. I'm mentioning this because, in a sense, we had to make a formal request for allotment of land, and we had great difficulty in finding out who would make such a request. Today the problem won't arise because the locus standi or the standing to file a case would be accepted. In those days you had to have direct interest. So Pilu Modi, of course, looked affluent enough so that he made an application for a piece of land. And he always used to tell me that he was mortally afraid that the government might accept it and he wouldn't know what to do with, how to produce the money. But fortunately the government refused the allotment to him. And just by that time emergency was on, and Justice Gandhi gave a very courageous decision in which he accepted the argument, our argument, that public property must be sold at the best price. It is now a commonplace of our constitutional law. But what I find a little amusing is that of the four petitioners, Pilu Modi was taken in preventive detention, as was Mrunal Gore, for other activities, not necessarily this case. One of the petitioners died of natural causes. And so far as the respondents were concerned, the builders got their land, although by paying a slightly higher amount, which amount by that time was quite reasonable for them. And a statue was put up in honor of Mr. B.R. Nayak. And so much for history's verdicts on what actually happens to people at the end of a case.
So the reactions of the Bombay Bar to the emergency?
I think that's a very, very valid point. You always have people who do not want to rock the boat. So you had a large number of people who did not articulately oppose it. But I am proud to say that as against that, bulk of the lawyers were quite articulate in opposing the emergency. And I'll give you two instances. Many of us were on the government panel to argue normal government cases. All of us refused to take government cases. This was a small thing, but still, it really meant that the government could not get the best assistance to support their cause when the emergency legislation was argued in the Bombay High Court. And most leading lawyers, even if they would not come out strongly against it articulately, would refuse the brief. Second was a more interesting episode. We decided that we should hold a public meeting to discuss the emergency. The meeting was to be addressed by no less figures than Chief Justice Chagla, by that time an advocate, a senior advocate, Chief Justice Shah, who had retired by that time, and Justice Nathwani, a very mild Gandhian gentleman. One could not expect three more sedate critics of the emergency. The police suddenly said that this will lead to public disorder and filed a case. And we thought that it will take time for decision about the case itself. So what we did was something very unusual. We said, let every lawyer who supports our cause appear as a lawyer. And we had therefore, if you see the law report, you will find the names of about 300 lawyers, or about, say, 30 lawyers and description 270 others. So the meeting itself was held in the court, because the court itself became a meeting, and it was a bigger meeting than we would have had actually in in the Jinnah Hall where people might not have been that keen to come. And I must say to their credit, Justice Kantawala and Justice Tulzaborkar courageously struck down the police order and said that we cannot imagine any relationship between public order and a meeting held of this kind. Of course, the Supreme Court duly reversed that in the days of Chief Justice A.N. Ray.
One of the major points that some of the senior lawyers I've spoken to have mentioned about the emergency is that there was a lack of coordination among different high courts because of media blankets, etc. So news from one high court could not travel easily to another high court. How did that affect your practice during the emergency?
No, I think it's true that some of these news reports, to use their elegant phrase, killed the reports of judgments. I mean, you would get the report saying this case has decided, then later on the censor would say kill, 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 which was a description that you should blanket out that news. In fact, they couldn't find a more elegant word. They used this rather homicidal word. But by and large, in India, we have one very unique advantage which people do not always realize. The legal fraternity is one of the uniting factors. And the fact that all judgments are given in a common language, happens to be English today, is also a uniting factor. So people would know immediately which court had decided what. And you will be surprised that, for instance, in the case of preventive detention, every court, excepting one, held that you could not detain a person at will and you must have reasons which could stand objective scrutiny. And this was known all over, so the judgments could actually be cited. What it really did was, a large number of people who would be on the fence were not willing to come out and speak, although all of them resented the fact of emergency and the subsequent excesses. The biggest block to the legal challenge to emergency was unfortunately the Supreme Court. And this is a very black or a dark chapter in the history of the Supreme Court. And it is amazing that a concept which was accepted by virtually all courts in India was found as not even statable by the Supreme Court in the majority decision in ADM Jabalpur. That was the real tragedy.
Okay, sir. Tell me about the reactions in Bombay to ADM Jabalpur, the judgment.
No, ADM Jabalpur essentially meant that you had, it was impossible then to oppose the emergency unless you were willing to either leave the country, as some colleagues did, or you were going to be mute and inarticulate. There was another equally nasty judgment which people do not easily recall. That was a judgment about the conditions of detention. In Bombay, we were able to get an excellent order, originally by Justice Vima Dalal and then followed by all courts, which depended on one paragraph we had found out from Justice Shah's judgment in a very different context. And the judge had said that since preventive detention was of a different quality from punitive detention, the restraints on a preventive detainee must be the minimum which were necessary to keep him from escaping or to keep him within detention. As a result of this phraseology, we were able to get prisoners the food of their choice, reading material of their choice, rights of people to visit. In fact, Bombay High Court in some ways was so hostile to the idea of some of those people being regarded as detainees, that they would give us convenient date. For instance, Madhu Dandavate and his wife were in different prisons, and we would take the same date for them to be produced in court so that they could meet in courtroom being brought from different corners. The Supreme Court in one fell stroke after the ADM Jabalpur, in the next judgment, I think it's called Govani, held that prisoners would not even have these rights, and they were subject to the normal jail discipline. There was no need to produce a detainee in court. And the result of these twin judgments, ADM Jabalpur, which didn't give you a chance to come out, and this judgment on conditions of detention, which treated a preventive detainee as if he was a regular prisoner serving sentence, was essentially to eliminate opposition other than political opposition. If you are willing to go to jail, of course, you are willing to speak out. So there was a certain amount of silence which descended on courts after that, after these twin judgments. Fortunately, the atmosphere was such that Mrs. Gandhi thought that she was very popular, and she then wanted to get it again ratified by an election. That failed.
Tell us about your move to Delhi.
In 1989, I was invited to be the Solicitor General. And of course, if you are the Solicitor General, you have to be located in Delhi. I was in two minds, because I am very much was very much a Bombay person at that time, and I was quite content with my work in the court. But then I thought I might, since I was coming to Delhi twice or thrice a month anyway, for given cases, I might as well move here. So I moved here as a Solicitor General. The government was extruded rather faster than expected. So within about 2 years, the Solicitor Generalship came to an abrupt end. But by that time, I think I was quite content with my work here. And the cycle in the Supreme Court, the atmosphere in Delhi, and I have continued ever since then.
So people speak about the culture of the Bombay Bar, the character of the Bombay Bar. You made the shift from Bombay to Delhi. What is the difference in cultures?
The fact of the dual system, I'll explain in a moment, being taken more seriously in Bombay has an impact on both the quality and the detachment of the bar. This is not necessarily Bombay versus Delhi. It is wherever the seniors have a system of keeping their distance from the clients directly and being briefed really by the advocates on record, whether you call them solicitors or advocates on record, does not matter. There is a greater incentive for a certain professionalism to develop. And it is this professionalism which is sometimes lacking in some other courts. I am not going to characterize it as a strength of Bombay or weakness of Delhi. It's really a matter of individuals. The essential thing is to develop this as a profession and not sort of reduce it to a trade. I think that's an issue which we can discuss later on at some depth.
Tell us about your personal experience moving from Bombay to Delhi, how that comfort level came about.
I must start by mentioning that I am not a stranger to Delhi, and the judges were not altogether strangers to me, because I used to appear fairly frequently in the Supreme Court. Not as often as one would, of course, as a Solicitor General, but I found that if you were ready with your case and if you put it in a reasonably persuasive way, the judges were extremely receptive. And I have never had any experience of a judge being deliberately obtuse or rude. I mean, sometimes you feel that the judge hasn't quite appreciated the point, but I am sure that is a reciprocal feeling, because the judge might also feel that the law does not follow the real issue in the matter, and that's part of the give and take of advocacy. But by and large, I must mention that Supreme Court consists of fairly courteous and learned judges. And you rarely have instances where you feel exasperated on those two counts.
And then your time as Attorney General of India.
Yeah. Well, I became Attorney General in 1997. I was very fortunate in two things, or really in three things. One, we had two prime ministers, Deve Gowda and Gujral, and whatever their political strength and weaknesses, so far as the Attorney General's office was concerned, they accepted without demur whatever advice was given. They never interfered with what advice, the point that the answer that they were seeking. They would send you the papers and their instructions were follow the Attorney General's advice. There was no question of putting any pressure. And I also find that if you have a reputation, that you are not likely to be swayed by any pressure on one side or the other, the people stop making that effort and they take the opinion without any demur. So, although we had quite interesting cases of Vinit Narayan and Lalu Prasad and others, there never was any pressure saying do this or do that. Secondly, we had an extremely able president who knew his work as a president, his constitution and his files. And the result was that the matters couldn't be put across to him without his doing his own personal study and coming to his own conclusion. So it was not somebody who was new to the intricate task of the government, but he would ask pointed questions and if necessary, turn to the Attorney General for advice, which he would, I think, almost invariably accept. And thirdly, we had a law minister who did not interfere with what was the work of the Attorney General. So the combination of these three, I think, gave me great satisfaction during my work.
Who was the law minister in Deve Gowda's cabinet?
Mr. Khallam,
Okay.
who of course was from Goa.
Okay.
And the fact that he was not, he was a slight stranger to the bar here, also was induced him to leave matters to the Attorney General and law officers rather than interfere.
It was also a very interesting time for parliamentary constitutionalism because it was very fragmented.
Yeah, it was a fragmented government, but I must mention one thing. The Prime Minister was, in Gowda's days, the Prime Minister was a hands-on person who would take a decision. I've seen him working in the cabinet, and he would sort of, with the help of the civil service, take decisions fairly rapidly. And therefore, you had a fairly prompt response of the government to anything that you wanted to be done. Now, for instance, this whole concept of CVC, which emerged out of Vinit Narayan's case, was a result of the government realizing that the manner in which political issues might involve certain amount of offences required some independent scrutiny. And instead of dilly-dallying, after a while, the government itself accepted. In fact, I made a statement to the government that we'll have a committee. And that committee's decision came through within a matter of 2 or 3 months and became a part of the law of the land. Now, it is not merely the government it's not merely the government accepting court pressure, because that's only a part of it. It also showed that the government meant business, and in a given time frame, it was able to decide what the scheme should be. One or two parts of the scheme were not accepted by the court. But that, so be it. By and large, the scheme was accepted. And this is partially because the government responded with a fairly strong committee immediately.
Any other instances which instructed you about the constitutional role of the Attorney General?
See, the Attorney General is not, to use the normal the phrase you use, the pet or the poodle of the government. He is an independent responsibility and a constitutional position. And I think I had this almost unique episode, I think in November 97, when Mr. Ramesh Bhandari, then the governor of UP, gave advice that Kalyan Singh should be dismissed and the assembly dissolved. Cabinet took that decision and said that there should be this dissolution of the house. At that time, my advice was not taken, so I was still away from the fray. That night, the President returned late in the night, about 11:30, and suggested that I should go over at about midnight. And we discussed the matter, and I said that the house could not be dissolved, and the advice of the governor did not appear to be constitutionally right. And although the cabinet had given the suggestion that not only should the government be dismissed, but the house must be dissolved, the president returned the advice. It so happened that next morning the Prime Minister said I should attend the cabinet and explain what had happened. And I had only to tell the president that, look, I am not concerned with the political decision whether Kalyan Singh should be there or should not be there. But it would not be possible in view of Bombay's judgment to defend such an action before the Supreme Court. And that was enough, and that's a unique occasion where the advice to dissolve the house was returned by the president, and that view was accepted by ultimately the cabinet. This also required a president who was fully aware of the constitutional nuances and you knew the Bombay judgment as well as one would want him to do.
All right, sir.
This is one. The second area where the Attorney General works, and sometimes this is not known, but it's actually in some ways one which makes you even more anxious, are cases where you deal with sentence of death. And people do. I had two occasions, and one was a military court martial, where there was an award of the death sentence. I am not going into the details, but I was told that the Attorney General has to decide what the advice should be. And
advice to the president?
To the president should be. And all I had to, what I had to do was to return all work, sit down, isolate myself for 3 days, read every line of the evidence, and then come to the conclusion, it so happened in that case, that the lesser sentence would be the more appropriate one. That although there was guilt, it did not deserve death sentence. Now, this is a very tough sort of an exercise, and it can, it's done quiet. It has to be done quietly. It has to be done with full responsibility, and I think it is done away from the glare of any possible publicity. And this happened to me more than once, and on each occasion, one had not only to peruse all the documents, but one could then appreciate the problem that a judge faces when he has to play God.
The role of the Attorney General in law reform, any experiences personally?
Now that we have law commission, very often what I would do as an Attorney General would be to send the suggestion made by a court itself to the Law Commission. It's not possible with the pressure of work for the Attorney General to sit and work out the whole the draft of a law. Although I was on a committee to draft the law regarding food standards and about Foods and Drugs Administration Act. But that's a difficult task to do. Drafting of the law itself is it's a fairly involved question. But the example I gave of CVC is an example where a fairly detailed proposal was made, which then had to be translated into law by a draftsman.
Some other incidents would have brought to focus the role of the Attorney General.
You see, the 11th Lok Sabha was running with the UF government supported by Congress. In December 97, Mr. Kesri announced that for some reason, good or bad, he was withdrawing support to the government. And the President had to decide whether the Lok Sabha should be dissolved or not. At this stage, we did not have any formal advice by the Union Cabinet that the Lok Sabha could be dissolved. And obviously government would be reluctant to give such advice unless the facts were very glaring. And I remember again President Narayanan suggesting that I should come over at night. And it so happens that I have the very copy because that which says that this volume was used by President Narayanan at 2 a.m. on 4th December 97 to sign the order delivering the 11th Lok Sabha, and he was good enough to sign it.
Can I get a shot of this, sir?
Yeah, sure.
This is the book.
This is the
and
he has got the
this is the book, and these are the words of President Narayan.
And of course, the elections thereafter took place within a period of 3 months, and the new government of Mr. Bajpayee was sworn in as the 12th Lok Sabha. But it also showed the very meticulous way in which the President used to act, and he had a very interesting approach which should really have been maintained. Namely, for every action that he took in the public domain of this nature about constituting a government or inviting people to form government, a press note was very carefully prepared in order that some sort of a precedent could be established as to how the President should approach an issue of that type.
The Attorney General is also the leader of the bar at the Supreme Court?
He is a leader of the bar because by law he is given the right of pre-audience. But the quality of his leadership would of course depend on his character and the eminence that he enjoys in the profession.
All right. The Attorney General is also ex officio member of the Bar Council of India.
Yes.
During your time, what was the level of involvement of the Attorney General's office in the regulatory capacity of the...
I must say that as far as I was concerned, I made it a point to attend every meeting of the Bar Council, except that I would not sit in the disciplinary jurisdiction of the Bar Council. But I thought one should really support the institution, which is not developed as vigorously as it ought to, because the Bar Council ultimately has to be the body which sets the standard for the whole profession. Well, let's assume it's trying its best, but it's not able to meet frequently enough, and it's not able to keep a steady presence in all the courts.
Your opinions on the level of professionalism at the bar? There are two parts to this question. One is, do you think that the level of legal service in India is poor, and secondly, discipline in the bar.
I am a little concerned about the fact that over a period of time, professionalism at the bar is getting reduced. And let me now explain what I mean by a profession. A profession owes duties to a society. And it's not merely a question of earning more money than somebody else, which is really the function of a trade, but to set standards and to ensure that a public need is met. Now, this would require the need for establishing an independent judiciary and a system of justice which is quick, inexpensive, and fair. These are the three standards that I would measure a system by. Now, in our dispensation, one can't really talk of any quick justice, except that sometimes I find that public interest litigation of importance is given a certain amount of expedition, which is desirable. There's nothing wrong with it. But so far as speed is concerned, we are not even using the existing weapons that we have. Law has a large number of weapons in its armory, which it can use. Why do cases not take the same amount of time in England? I'll tell you the reason. The costs of litigation are made so heavy there that frivolous litigation is completely discouraged. To give an example, today an adjournment in the Supreme Court, often taken for the most trivial of reasons, costs the client lakhs of rupees. Now, there is no earthly reason why, if two large companies are fighting, their actual cost should not be awarded at the end of the litigation. However, virtually every decision of the Supreme Court will end up with the words costs to be borne by each side, or no order as to costs. Essentially, what should be done is that the actual cost should be given, so that unless a party has a strong case, it would not go to court. Unless the party has a strong case, it would not defend itself. In England, you will not raise frivolous issues because the cost of the issue will be borne by you. Even if you may win the case, you may ultimately lose the cost because that issue which you raised was worthless. So first is costs. The second is refusal to give adjournments. Just consider this. Supreme Court is a court of appeal, which means that it works on, or it should work on, material which is already available before the court which has given the judgment and against which the appeal is filed. In spite of this, virtually in every matter, affidavits upon affidavits are filed, so that almost a new case is made out in the Supreme Court. Now, there is no reason why affidavit should be filed unless there is something remarkably new which has transpired since the judgment. And there is no reason why adjournment should be given. Thirdly, in all my more than 50 years at the bar, I have not seen anyone being sent to jail for perjury, excepting in one case where a man was sent to jail under the contempt jurisdiction for misleading the court. But perjury prosecutions are hardly known. Now, if these weapons are used, litigation would go down and it would be much quicker than it is. The second problem in professionalism is this. I mentioned the names of Sirvai, Gupte. These were in some ways our role models. But they were not the people who had the largest number of briefs, by no means. On the contrary, they would take only such briefs as they could read and they could attend. they would not take a brief unless they would be able to actually be present in court. You will be surprised how frequent it is that senior advocates are not able to reach the court in time. Let's put it charitably by saying that they couldn't run fast enough. Essentially, it is because they have amassed more work than the work which would be they can handle with the meticulousness that it deserves. Therefore, the fact that a man has more briefs, the fact that a man earns more, does not make him the best lawyer. This is the problem where the profession is in danger of becoming a trade. And the moment it becomes a trade, many other practices come in. Sometimes when I go to a law college, I am asked a question: what is the most important quality of a lawyer? And they are sometimes surprised when I answer that in my view, the most important quality of a lawyer is his credibility. If he makes a statement, the court would accept it, because the court would know that he would not mislead the court or his colleagues. If you are a professional, you owe a duty even to your opponent. If a question is asked as to what happened on the earlier occasion and what had happened was adverse to you, you have to get up and say that it was adverse to you. You don't have to sort of develop selective amnesia. So these are the areas where professionalism is very, very critical. And one way, of course, to resolve it, which unfortunately has been rejected, is that in the highest court, there must be a period of waiting before you start practicing. When I started practice in the Supreme Court, and that was some times ago, one could not appear in the Supreme Court unless one had spent 7 years at the bar, excepting in a case which you had argued yourself. So I had to obtain special dispensation that I had argued or I had appeared in that case, and therefore I should be allowed to appear there. Today, virtually any lawyer, why virtually? In fact, any lawyer who gets qualified can immediately practice in the Supreme Court. Now, the problem is not about not allowing him or allowing him. The problem is the court doesn't get the assistance that it deserves. The court must have the best assistance possible that the lawyer can give. But if the lawyer himself is not equipped, if he is a raw lawyer, the quality of assistance is bound to deteriorate. Now, if you say that you must have certain standards of, say, training before you become a lawyer, or of practice before you go to a higher court, people will call it elitism.
No, I've always wondered why in the Supreme Court you have a qualification exam to become an advocate on record, while to speak in front of the court, you don't need any sort of qualification except an LLB.
Right. The first is very important, although someone has ventured now to say that even that should be done away with or diluted. But it is absolutely essential that the advocates on the record must have a certain standard before they can actually file their appearance. But your second question is more valid one, namely, second observation, that how would a lawyer be able to argue immediately on the next day? I mean, everyone is not what was said about Erskine, that with his very first case, he became the leading lawyer in England. I mean, if you actually see the Supreme Court functioning, you will find sometimes examples where you really feel for the client, because the lawyer would show ignorance about the facts of the case. And you will be surprised that the judges have to tell him what his case is. And the judges have worked much harder on their briefs than the lawyers have. I mean, it's a matter of perennial astonishment to me that a judge who is to admit 40 or 50 matters sometimes knows more about his cases than the lawyer who has only 2 matters before him does. So this is what I mean by professionalism. A sense of responsibility not only to your client but to the court, and if necessary even to the other side.
You have experience teaching, lecturing in law schools, colleges across the country. Certainly there is a deficiency of good quality faculty. How does legal education deal with that?
I must here draw a distinction which happily can be drawn now after a few years of 5-year courses. I normally take some young junior for a while as a part of a guild system where someone has a view of how a court functions, how a lawyer works. I must tell you that the students who come from 5-year courses are among some of the best that I have seen. In fact, I have to tell some of them that they are better at their age than I was, because we all were under that 2-year system of picking up the law. So first of all, a gap is developing between 5-year courses and the other courses. There is a clear case for a 5-year course for law being extended or being given certain privilege, certain advantages as compared to the others, because they really produce excellent lawyers. One of the problems, of course, is that the best of them tend to work for corporations, but so be it. The second thing is what I had mentioned, that every senior lawyer must have the opportunity and then the corresponding responsibility to lecture in a neighboring law college at least 5 times or 6 times a year. This is not an onerous task, but this is something which can be arranged, which requires some adjustment of the college and the course. And frankly, if you keep it on a Saturday morning, I'm sure we'll be able to arouse at least 50 colleagues in the Supreme Court who would be willing to come and give lectures. But the third, of course, is the standard of our exams. We still put far too much emphasis on the written test. We have started, some time ago it was done with the help of the British Council, and now we have started an institution on our own of advocacy, where students or really lawyers learn the art of examination, cross-examination, presentation of cases. This is a very important part of law, which is not taught in any college. And this is the third area which can actually be put in the curriculum, although the way to teach it and the way to measure the excellence may be difficult.
The relationship between the senior bar and the junior bar. What are the responsibilities of the senior bar when it comes to mentoring the junior bar in their path through the courts?
Well, there are 2 things. One, bar is very much a brotherhood, and it should be open for any young junior to walk up to a senior and to ask for his advice. He may not get a ready-made answer, but surely he can be shown the route. And we always had colleagues at the bar whom one could go to and ask for advice on where to find a certain type of law or which is the relevant case on a given subject. I gave an instance of Mr. Sirwai earlier, but he was not there are many others who would be willing to help. So this is one field where you have to help. Second is to take juniors, although for a short period, because it becomes very difficult to maintain a large chamber, particularly in where the practice is of a type where you are going from court to court and you have a whole range of cases. But at the same time, all seniors, I think, essentially make that effort to keep some junior for a while so that they can learn the technique of actual reading a brief and then seeing how it is presented to the court. Thirdly, I think it's a very important part of the duty of a lawyer, and particularly a senior lawyer, to do some cases on a pro bono manner. I have mentioned 2-3 cases which I did, which it's not something exceptional. Most seniors do it, but it should be done in a more methodical way, where you contribute something to the profession which has given so much to you.
Let your verdict give us the answer.